So let's shift the conversation and talk about, activism. So the last couple of days, Kenyans have been expressing their feelings with regards to the announcement by the IMF on the lending to the country 257 million shillings as support for its various programs. Guys went onto social media, they went onto IMF's social media pages. We talked about this on radio. There's one activist who is called Mutemi, who also went on social media and he created some posts that landed him in trouble. Not the first time that Mutemi has landed in trouble because of expressing his views and his opinion. He was taken to court. He was released on some bail and he was also given some instructions by the courts. Now, we want to understand what those instructions were and what exactly it means then to this particular push. Civic awareness, civic activism. When somebody wants to participate in a conversation, do we have the freedom or not? Joining us, we have Winfred Gakii. She's a program officer, civic space at Article 19. Alongside her is Demas Kiprono, who's a campaign manager at Amnesty International Kenya. Let's start with you, Gakii. Good morning.
Good morning.
It's good to have you on the show and welcome to the Situation Room.
I'm happy to be here. Thank you.
Demas, good morning. Good to have you on the show as well.
Same here.
So let's start by you helping us to understand the issues surrounding Mutemi Wakema's posts and then what has happened in the corridors of justice. Gakii, you can just explain.
So what happened with Mutemi Wakema is that he was arrested on Tuesday at night, and up to now he has not been charged. So the following day, the state made an application to detain him for 14 days so that they could conduct investigations. And these investigations are pegged on the Computer Misuse and Cybercrimes Act. So these are false publications. You will recall that Mutemi had posted a picture, decrying these additional loans that the president wants to procure with IMF, and so that is the basis upon which he was arrested, and the state wanted to detain him, but the same was rejected yesterday. However, ordinarily, once the court rejects the application to detain an arrested person for longer, they would make an order for his release. But what we saw is that a bail terms was set at a very inordinate, bail was set at 500,000 Kenyan shillings, which is extremely high, especially in this difficult COVID-19 pandemic period where, everybody, most people have lost income. So, and, that was, this is extremely problematic because the very essence of bail is only to ensure that someone attends court or is able to cooperate with investigation officers. But in a concerning turn of events, this did not happen.
Is there a threshold that one would expect these bail terms to be set at, given whatever it is that is understood to have brought that individual before the court of justice? Is there a limit? Is there a scale? As in, like, if I kick your left foot, you can only charge me 20 shillings. If
you kick both,
if I slap the back of your head, then this is the sort of bail that I should have. If I stare at you badly, are they such structures?
So what happens is that we usually rely on the discretion of the judges. However, there are guidelines in place that guide the judicial officers and police officers when setting bail and bond. So there is a guideline. Currently, it's called the Bail and Bond Guideline, which was developed by the National Commission on Administration of Justice, which is couched under the Deputy Chief Justice. And there are certain principles that are supposed to guide the judicial officers, and key among those principles is the presumption of innocence and the right to reasonable bail terms. So you're supposed to, the judicial officer is supposed to exercise the discretion, but should ensure at best that the bail terms that are set are reasonable. So for instance, Mutemi has not been charged yet. So setting the bail at such a punitive, high level, it is almost as though you're saying that, he has committed this crime.
Can I ask Can I ask a question, Gakii? If a charge had been leveled against him, would this 500,000 shillings then be justified?
So there is no justification for setting inordinate bail terms. So whether he has been charged or not, the judicial officers are supposed to be guided by the right of presumption of innocence and also the right of the accused person or arrested person to reasonable bail and bond terms. So it doesn't really matter whether he is charged or not. It's just that that discretion is supposed to be exercised in a very restrictive manner so that you do not go beyond what is necessary to ensure that the arrested person or the accused person is able to cooperate with the police or is able to attend court.
So Gakii, do I understand you to be saying that the magistrate misused the discretion that is accorded to them by our laws?
So my opinion is that that bail amount is inordinate, is extremely high. Even for the proposed crimes that were being investigated, and especially in the interest of and especially in the public interest, because remember what Mutemi Wakiama was speaking about was asking for accountability, asking for transparency for the loans that Kenya had already been loaned. So essentially, Kenyans are asking, why do you want more loans when you haven't accounted, for the loans that you've been given before? So these are what we call public discourses. So when you start setting such bail terms, then it starts creating fear, even among ordinary citizens, about, can I comment about, various decisions that are being made by government. So it's against that backdrop, then, we say we should be exercise, restraint so that we don't effectively stifle free speech, especially speech that is furthering public discourse.
Demas Kiprono, the campaign manager at Amnesty International, was Mutemi Wakiama told not to make any public comments on this particular matter of loans and Kenya borrowing and public debt?
Yes, in fact, one of the most outrageous incidents where the court has actually been complicit in stifling freedom of expression was that order which basically required Mutemi not to comment about IMF loans in any forum. It also asked him not to comment to any other person. This, in my opinion, is quite unnecessary, and it's also too punitive in terms of the state through the courts dictating what topics and what issues someone can talk about, and especially since it's been established that these are matters of public interest that had been expressed by many, I dare say thousands upon thousands of Kenyans through different social media accounts. Well, the other problematic thing, and perhaps which also lends credence to the problematic matter of the conduct of the judicial officer, is that the court also ordered that his social media accounts be suspended. And we all know that the state cannot order my Twitter or my Facebook account to be suspended. Twitter and Facebook have their own modalities of doing that, and they have their own community guidelines. But let's also just step a little back and think about what Mutemi was discussing. These were matters that were within the ambit of Article 33 of our Constitution, where every Kenyan is conferred the right to seek, receive, and impart information, regardless of frontiers and through any media. This right does not extend to certain things, does not extend to propaganda for war, incitement to violence, advocacy for hatred, among other things. Here we see a case where the court constructively and also the state have created their own limitations to freedom of expression that are outside the ambit of what was contemplated by the authors of the Constitution.
Demas, there's something I want to ask you. You say you've mentioned the court, I understand that, and then you mentioned the state. Yes. What evidence is there to show that indeed, as you have alluded, the state influenced this outcome? Because from what your colleague Gakii mentioned, it is this judicial officer has discretion. They have the leeway. So is it possible that we are dealing with the perception and the leeway that a particular individual has decided to bring to bear on this case, and that the state may not necessarily have influenced that outcome?
If you look at the order of events in this matter, is that Mutemi was arrested by DCI officers at the wee hours of the night. And then he was presented to court, and they applied for him to be held for 14 days as they conducted investigations. This means that the body that pushed or that triggered this order of events was actually the executive arm of government. And in fact, now we wonder that the judiciary is actually now becoming complicit in the limitation of rights of citizens of Kenya. And remember that the right of the public to participate in public decisions and public discourse is a principle of governance in Kenya. It is protected under Article 10, and it dictates that all levels of government allow Kenyans to participate in decision making. This issue is an issue where Mutemi Wakiyama is a taxpayer. In one way or another, he will pay for these loans. So he is directly affected by the IMF loans, and he should be able to speak about, converse, criticize this public borrowing that we're seeing in Kenya.
Demas, can I ask you really quickly before you go to your next point? I just want a point of clarification. Here, when you talk about the fact that because he was arrested by DCI officers, is this clearly indicative that it was an order from the executive?
Well, the DCI normally is, as much as the National Police Service is independent, it is an appendage of the executive, especially when it comes to politically motivated arrests and sanctions.
Okay.
Yes.
So does that, just to jump a little bit off of that, does that mean that if anybody today, if CT, for example, makes a statement, for example, that is of some political nature that rubs somebody somewhere the wrong way, if, for example, he then were to be arrested by DCI officers, does that mean that they were acting under a direction
at the behest
of the executive?
Not necessarily. It just might be an overzealous person within the DCI who perhaps felt very strongly about what was discussed. We really have no evidence that a phone call was made or a wire was dispatched, to say the truth.
Okay.
But we have seen this before. We have seen Robert Alai, we've seen Cyprian Nyakundi, we've seen other online expression agents who have been arrested, especially when they spoke about certain people within society.
But by the same token, Demas, we've also seen these very same courts issue edicts that would be considered at the very, very least to be anti-establishment. They have not favored the state in any way. So if we were to put these things alongside, would I be wrong in assuming that any time one of our our judicial system processes don't favor a certain thought process, then they're considered to be anti-freedom, and when they favor, then they are pro-freedom? Is it not possible that they could simply be following the law as they understand it?
Well, perhaps we should step a little back to see what decisions have been coming out of our court, especially since the passage of the new constitution. Initially, there were a lot of very progressive and very affirmative decisions when it comes to human rights, especially issues of freedom of expression. But these decisions usually emanate from the High Court, and they emanate from petitions which really converse on issues. For example, what Mutemi Wakiyama was arrested under, we suspect, is perhaps because he commented about a senior state officer in a certain way. But there was a petition by Robert Alai which declared undermining authority of a public officer unconstitutional. And basically, the court affirmed that citizens should be able to comment about leaders in an open and democratic society. And the comments might as well be critical of them. We have noticed that this edict or these judgments really do not cascade down to the magistrate court, where a lot of these abuses happen. So I am not saying that the judiciary is anti-right, but I'm saying this is an incident where the judiciary, in our view, is complicit in the muzzling of fundamental human rights. That is something that is of wide public interest.
Okay. What are his rights? What are any Kenyan's rights right now as we're looking at it in terms of expression when we're talking about things like this? Let's look at this particular issue when a lot of people in the country were talking about, not being comfortable with the government rather, getting these further funds via the IMF. And I guess this is something that both of you can look at. Gakii, could start with you. What are his rights? What are anybody's rights when it comes to expressing themselves publicly about such matters?
So the first thing with regards to this IMF issue is that everybody has the right to access information on the process through which this decision to request for this loan was made. And if that information is not shared publicly, then people have a right to express themselves, to protest the failure of government to, give information, make information public, and make information public about the process through which the decision was reached. The people also have a right to publicly participate in such decisions that have significant economic impact on the country. So whenever someone feels or anybody feels really that they were not consulted or the public was not consulted, then they have a right to express themselves in that manner. They have a right to protest either online or offline to say, there was this process, we were not made aware of this process, and so we want to know. We also want to express our opinion, opposing that move, opposing that decision. So under Article 33 of the Constitution, every Kenyan has the right to express themselves on any issue whatsoever, and especially issues that pertain to public governance, including transparency and accountability issues.
Gakii, do you feel that then the DCI acted outside the purview of the functions that they are mandated by law to carry out?
Remember that the DCI is an independent body. So what we usually advocate for is that due process is followed. Of course, when you look at the turn of events, you can clearly see that there's likely a state hand in this, but at the very best, due process must be followed. So, for instance, this application that they were making to detain Mutemi Kiama was completely unnecessary. It was just an attempt to continue denying him his liberty of movement further.
But Gakii,
and remember
if
that
I may just interject, if you don't really mind. I mean, if I hear what you're saying, but then that is subjective. My question was actually very specific. Did the DCI act within the purview of them, their mandated functions? Did they do anything that is outside the purview of what they're expected to do?
So I would say that at the moment, nothing clearly can indicate that they went beyond their powers, because but the arrest that was made at night. Remember that you don't have to pinpoint, at the exact conduct, but a trend could point towards a violation. For instance, was it really necessary that he was arrested at night? And this is something that we have seen, where activists are arrested at night, so that they at least spend a night in the cells before they are arraigned the next day. So you can see a clear trend, that is meant to create fear in the public. So I would say it's not so much about pinpoint. It's about this trend and what it means to other people and what it means to the public generally,
If organizations such as yours, Article 19 or Amnesty International, and any other feel that the DCI then at some point goes beyond what they're supposed to do, would you take this case to court? Go basically to court and say, we feel that this independent office is overstepping its mandate or is curtailing people's freedoms?
Absolutely. Remember that you don't really have to show that a violation has taken place. So under our constitution, under Article 22, you are allowed to go to court if there is a threat. So it doesn't have to be a violation that has already materialized. Even the very threat of it through these trends that we have been seeing. Remember that Kiama also 10 months ago was arrested in a similar fashion, and eventually he was not charged. So if you can show a trend, which points to a violation or even a threat to violation of your rights, then you can go to court, and organizations such as ours at Article 19 Eastern Africa would go to court on that basis.
Why haven't you? Like you've said, this is not the first time that Mutemi Kiama has been arrested in this manner. It's not the first time that activists have been arrested in this manner. Why haven't Article 19 and Amnesty and others gone to court?
So remember that when you want to lodge a petition in the High Court, there's a lot of preparation that goes into it. So for instance, if it's such a case that, such as the one that we are discussing, remember that you have to join pieces together so that you can make an airtight case. So for us, actually, there's a pending petition that we want to lodge at the High Court of Kenya, a constitutional petition regarding these attacks on journalists and activists. And so it's a live issue, and we are currently in the process, and I'm sure we will be lodging the same in a few months' time.
All right. So we want to thank you very much for joining us and speaking to us this morning. And we'll be following up on this particular public interest case for Mutemi Kiama and any other activists. And your organizations, of course, are in the forefront in trying to secure justice on his behalf. Asante sana for speaking to us. Winfred Gakii is a program officer at Civic Space at Article 19. And Demas Kiprono is a campaign manager at Amnesty International Kenya. Thank you and have a lovely day.
Good morning.
Thank you.
Asante sana.